Hey, welcome back into Eye on Agriculture. I'm Brityne Rucker. The Supreme Court's recent decision overturning Chevron Deference has sweeping implications for food and ag policy. To help break this down, we're joined now with Roger McEowen, professor of agricultural law and taxation at Washburn University. Roger, let's start with the U.S. Supreme Court recently repealed an administrative review rule known as that doctrine. What's the implications on agriculture?
Well, potentially, Britain, I think it could be huge. The doctrine stems from a prior court decision of the U.S. Supreme Court back in 1984. And under the doctrine that came out of that case, courts are to defer to administrative agency interpretations of a statute where the intent of the Congress is not really clear or it's ambiguous, and where the interpretation of the agency of that ambiguous statute is reasonable or permissible. And so that set a pretty low hurdle for the agency to clear. In other words, if the agency's interpretation of a statute was not arbitrary or capricious, or as the court said, it's as long as it's not manifestly contrary to the statute, then the agency's interpretation will be upheld. And what that meant for farmers caught up in administrative appeals, for example, with USDA or sub-agencies, is that once they got through the administrative process where USDA was acting as jury and judge and executioner, they could get to a court, but when they got to a court, they were already behind because the agency is presumed correct. And just a few days ago, the Supreme Court said, we got it wrong in 1984. It's not the administrative agencies that are experts on interpreting statutes, it's the courts. And so now the courts will make those determinations and not administrative agencies.
And Roger, the court decided another case the day before that also bears on administrative appeals. Can you explain that and how it connects to the repealing of the Chevron Doctrine?
Yeah, it's a big case. It didn't involve agriculture. It involved the Securities and Exchange Commission, but they levied a fine against a hedge fund operator of over $300,000, and then additional penalties that ramped it up to about $1 million. And that was through the administrative process. So again, you had the agency acting as the juror, the prosecutor, and the executioner. And he said, look, I should be entitled to a jury trial of my peers under the Seventh Amendment. And the Supreme Court said, that's right. So when you combine that and the fact that USDA appeals use the same process and rules that the SEC does, and so does EPA, and so does the Corps of Engineers. So just about any type of administrative battle a farmer is going to get into, they may be entitled to a jury trial. And then the standard of review is not going to be Chevron deference. It's going to be the court interpreting whether the agency wrote the rule right. So you put those two together, I think that's a major bonus for agriculture, and it should make it easier for farmers to prevail in administrative agency type cases.
Very interesting. Well, Roger, thanks so much for coming on the program. Everyone stick around. Eye on Ag will be back after the break.